Good afternoon and welcome to Division 4 of the Colorado Court of Appeals. Division 4 is comprised of myself. My name is Bob Hawthorne. I'll be presiding over the proceedings today. To my right is Judge Lorenzo Marquez, and to my left is Judge Elizabeth Harris. And we will be the division that will ultimately reach a decision in this case. And today we have two cases on our 1:30 docket, but we're going to have to take a recess between the cases because we have to reconstitute the court with a different judge. So to begin with, counsel, do either of you have any questions about our practice and procedures and protocol for arguments this afternoon?
No, Your Honor.
Thank you. And as you know, counsel for appellant, the timing here is self-monitoring, and you can reserve the amount of time you wish for rebuttal. And the lighting system on the podium will tell you when you have 5 minutes left, the yellow light goes on. And I'll remind you that we are now live streaming our oral arguments. You can see the cameras around the courtroom. I don't believe that there's anything sensitive in this particular case, but you might keep that in mind that we are live streaming during the oral arguments these days. For those folks who are in the gallery, I'll ask you to make sure that you turn off any cell phones or any other devices that you might have with you that might interrupt the arguments today. And with that, unless counsel has any other questions, we're ready to proceed in Byrne versus DCP Midstream LP. That's case number 17CA1190.
Good afternoon. My name is Edward Byrne. My number is 6960, and I'm here representing the plaintiff, or the appellant, the Byrne Trust. The trust owns a perpetual interest in revenues from the processing and sale of natural gas under an award of arbitrators, which was affirmed by this court in earlier case in 1990, Associated Natural Gas v. Nordic Petroleum. It involved an underlying contract known as a gas purchase and processing agreement. I represented Nordic in that litigation, in the arbitration, the litigation, the appeal, and the trust's interest came about as a fee in that earlier case. The arbitration award itself is quite short. It's 2 pages long. First, the arbitrators determined that the trust's predecessor was entitled to a perpetual interest after payout of certain capital costs of 10% of distributable revenue from gas produced in a specified area up in Weld County. The second, and here, rather than making any further determinations, the arbitrators entered orders, first telling DCP's predecessor how to compute the amount owed with respect to direct operating costs, capital costs, and with respect to something called the fractionator, which separates the liquids from the gas. But then it goes on, and something that's at least unusual in my experience, they entered an order to pay, not a determination that the amount was owed, but an order to pay the amount determined in accordance with their previous order and make the payments and to provide the statements monthly after payout. Early in this litigation, the parties entered into a stipulation to the effect that both the award and the underlying GPPA were binding on DCP and enforceable by the trust. The trust's appeal involves primarily the refusal of the trial court to give effect to the award with respect to several things, but in particular the trust's right to proceed by contempt and to force compliance with the award, and to make the provide the monthly statements of the amount due, and then to pay the amount that was shown as due.
Counsel, I'm sorry to interrupt, but can I just jump to a question
Sure.
about the contempt issue? I wondered what effect a contempt order would have after the jury's verdict and the judgment. In your briefing, you say that the purge order would require DCP to pay what it owes, but isn't that exactly what the judgment also requires? What's
No,
the
wait.
benefit? What is the benefit of a contempt order?
The benefit of a contempt order is that if we had been allowed to proceed with the contempt in the trial court, it would have been a much faster procedure. It would have involved enforcing the express provisions of the order. We would have been entitled to at least claim attorney's fees, and there would have been the ability to make an immediate appeal from it.
But why would it have been faster? I guess I'm not getting that, because wouldn't DCP have raised the exact same defense, which is, we don't think we owe the amount they say we owe, and we get to deduct our costs?
Well, when we made the motion for contempt, we made a motion for contempt in the trial court, and the requirement for obtaining a purge order in the trial court is to make a prima facie case that they're in violation of the order. And that was easy to do because the order requires them to provide monthly statements, which they never did. In connection with this litigation, they'd provided a spreadsheet which covered a period, and I can't quite remember how many months it was. I think it was 120 months, in which they never paid the correct amount.
Right, so you wanted the correct amount. You didn't want the
So of course, we'd rather proceed by
spreadsheets.
contempt rather than in 2014, rather than a trial with all, going through the whole discovery process and then going through a trial, whereas once in a contempt proceeding, once you've shown the prima facie case, the burden shifts to the other side to show that they are not in contempt or that they have to purge the contempt. It's very much better remedy than the ordinary civil litigation, and the arbitrators went out of their way to phrase their decision in terms of orders. And I think that may have been in part because one of the arbitrators was the former Denver District Court judge, who would know the effect of including orders in an arbitration agreement once it was confirmed. So we would have much preferred to have proceeded in a contempt proceeding and attempted to do that, and the trial court didn't let us. So it's a huge difference.
Mr. Byrne, may I ask you a question?
Sure.
I'm sorry, I don't want to interrupt your train of thought if you're still answering Judge Harris's question.
No, go ahead.
I wanted to ask you, you made comments in your opening brief, or several times in the briefing, that you thought that the arbitrators had decided and defined what payout means, and that they had decided that payout means a single event rather than potential series of events.
Yes.
Can you tell me what the language is in the arbitration award that convinces you of that?
Yes, the language in the arbitration award, first, it's an order. It isn't a determination that they're required to pay. It's an order to pay, and let me see if I can read the small print. It's on page 2, and it's sort of a two-part. The respondent shall report the status of the payout calculation annually, shall report, until such time as payout is reached. It isn't what, it seems to me the clear meaning of that language is you have this first period where they're providing annual reports, then you reach payout, and after you've reached payout, then you have to provide the monthly statements and make the monthly payments. So we believe that to comply with that order means that payout only occurred once. There's still a question when it occurred, but we think the language, the clear meaning of the language in the arbitration award is that time is divided into two segments, up till payout, after payout, and there's not a third of going back out of payout.
So there's no express finding by the
No.
arbitrators that
No,
payout
it's
is a single
contained, it's
event.
implicit in the, or explicit in the order they entered, not, and there again, it goes back to the question you raised. Why does that make a difference? And the difference, again, is enormous because the ability to proceed by contempt from a plaintiff's point of view is so much better than having to go through entire civil litigation with discovery, with trials. Here, there is no question but they weren't paying. There's no question but that they were not providing statements. And we think the trial court should have issued a purge order.
Well, is there something we can do for you at this point? Because now you have gone through the litigation. So if we were to say, well, it would have been a lot more efficient to just let them proceed in a contempt proceeding, then what would the remedy be?
The remedy we've requested is a remand to the district court to hold the contempt proceeding based on not only and here there's other issues that were decided which are now binding because DCP didn't appeal them, as to as to the revenues that they should have been including in the calculation, and as to the direct operating costs they were not allowed to include. So again, we think that's a remedy that's available, and we should have been allowed to have proceeded in that type of proceeding. But it also goes to the future. This is a perpetual interest. And part of the perpetual interest is in our view, is the right to proceed by contempt if there's violations of the court orders in the future forever. And that, again, is a much better remedy than a civil action.
Could I ask you a quick question about
sure.
your deck judgment claim? In your briefing, you say that the court should have adopted or addressed all of the proposed findings of fact and conclusions of law?
Yes.
For the deck judgment, okay.
Yes,
So can you explain what the exact problem is with the fact that the court didn't do that? Are you saying that the court failed to resolve some of the disputes between the parties or did not fully and finally determine the rights of the parties?
We had made specific requests, and this relates primarily to the award. We had made specific requests for specific findings as to the effect of the arbitration award, and a lot of it is just sort of non-controversial. We had thought, but we thought that since this is a perpetual interest, and since I would prefer not to make a future out of continuing to be involved in litigation with these people, that we should resolve all those matters up front, and we submitted the proposed order to do that. DCP did not object to any of the provisions in that order, and we think under the declaratory judgment statute that the court was obligated to decide those issues. Indeed, the court, in its equitable order, cited as the law on declaratory judgments, and this is from case law, but the proposition that the trial court should decide all the issues raised, including if deciding them, if need be, adversely to the proponent of those issues. We requested them to do that because, again, who wants to keep litigating the same issues over and over again? So we put them all in front of the court, and the court refused to enter any of them with respect to the award. The only mention of the award is actually to let me get this, the equitable order, in that the judge referred, he made the statement that, of course, the award and the GPPA remain in effect, and under these, you're entitled to go audit the books. Well, the award of the arbitrators was far more, it didn't give us the right to audit the books. It imposed the duty on them every month to provide statements to us, which they never did. And with the statements, to make the payments. So we think the trial court was obligated under the declaratory judgment statute to rule on those issues, all of which had been raised and all of which are legitimate issues going to the future, because the equitable order primarily relates to from now till whenever perpetuity ends, which will be when they run out of gas in the field.
You have about 10 seconds left, Mr. Byrne.
Oh, well, our requested relief is, first, we've asked you to cite one of those issues that was in the proposed order, which relates to the whole issue of capital costs. Then we've requested a remand to the district court for a determination of which of these other proposals should have been ruled on and how they should have been ruled on. And after that's done, so we know what the law is, to hold the contempt proceeding. Thank you.
Thank you, sir.
May it please the court, Claire Pennington on behalf of DCP Midstream, bar registration number 37896. I'd like to first begin by addressing the arbitration award and whether in fact that award addressed the specific issues that were before the district court in this case. And as the court properly found when it denied the appellant's motion for partial summary judgment regarding the arbitration award, that award did not address the issues that were before the court and did not determine the issues that were ultimately submitted to the judge and jury. Most critically for this case, those issues included whether under the controlling contract, the GPPA as it's referred to, payout was a one-time event that had occurred sometime in the early 1990s, or whether it was an event or a status that the perpetual interest could move into and out of, depending upon the relationship between the distributable revenues as calculated under the GPPA and DCP's capital costs that it incurred in order to gather, transmit, and process the gas that was produced out of the area of mutual interest. That first issue about whether payout was a one-time or transient event the district court here determined by granting DCP's motion for summary judgment pre-trial. That is one of the issues that is before you on appeal, and we argue in our brief that it was not properly preserved, but I'll address it for a moment should this panel decide that it was. The court's ruling on that contractual interpretation issue was correct under the plain language of the agreement.
Can I ask you a quick question? I'm
Yes.
sorry to interrupt.
Mhm.
In your briefing, you talk about the course of conduct by the parties. Is that something we would consider if the language is unambiguous?
There was course of conduct evidence presented at trial for a different purpose, and in that case would still be relevant. So under the contractual interpretation issue of whether payout was a one-time or transient event, that was determined by the trial court and can be affirmed by this court based on the plain language reading the contract, which explicitly talks about the expansion or addition to the existing facilities and the associated capital costs being able to be recovered by DCP, and talks about how payout includes, as part of its definition, the construction of new or expansion of existing facilities, which can only make sense if capital costs can continue to be recovered throughout the duration of this contractual relationship. There was another issue related to the GPPA and whether DCP was properly calculating the perpetual interest payments that had to do with what the contract means when it said the portion of capital costs attributable to the facilities utilized for the gathering, processing, and transmitting of AMI gas. For that issue, the district court ruled that the meaning of the contract was ambiguous, and it was one of the issues embedded in what was presented to the jury. And with respect to that issue, which went to the broader question of whether DCP had was properly allocating capital costs under its volumetric method for the calculation as it was referred to in the trial below and in the briefs here. As to that issue, there was course of conduct evidence with regard to how DCP had done that allocation in the past, how the parties had understood it in the past.
So that table that's in your brief, that shows the in and out for the payout, that's not supposed to go to whether or not the payout is a one-time event or a potential multiple event?
Thank you, Your Honor. So there was another issue that went to the jury that was related to all of this, which is that although the court had determined that as a matter of law under the contract, payout could essentially be a state you could come into and out of, one of the theories that the plaintiffs were allowed to present to the jury was that while it could go in and out of payout as a contractual matter, it never had as a factual matter. And that was because the plaintiff's theory at the trial, or one of their theories at the trial, was that in order for the perpetual interest to go back out of payout after that very first time that it was in payout, the capital costs that DCP would accrue would have to exceed its cumulative net profit from the beginning of the contractual relationship through to the present day, meaning that DCP's expansions and additions in the area of mutual interest to its facilities, let's say today, for example, would have to exceed in cost all the profit DCP had made on its processing of the natural gas from the AMI over the entirety of the now nearly 30-year existence of the AMI and this contractual relationship. So the plaintiffs were allowed to present that theory to the jury as a factual matter. And so that's another place in which the extrinsic evidence came into play. But there's no question, and in fact the jury was instructed, that the court ruled as a matter of law pre-trial that as a contractual matter, payout was a transient state that could go in and out. And with respect to the factual matter of whether DCP had properly accounted for and paid under the perpetual interest, Judge Harris's question during appellant's argument was exactly right, which is that is precisely what was presented to the jury and to the judge, and exactly what the jury found in its verdicts for each side, and exactly what the judge considered when issuing his declaratory judgment order. And that was the heart of this case. All of the disputes about how you allocate capital costs, whether the correct revenues were included in that computation that DCP has been doing, whether DCP inadvertently omitted the collection of capital costs for several years during the payment and during this contractual relationship, is what was presented and considered. And the only way for the fact that there's certain portions of revenue that the jury found DCP still owes, and certain portions of capital costs that the jury also found that plaintiff owes back to DCP. The only way for the fact that DCP owes money still to the trust to be a contempt of the arbitration award would be if the arbitration award had addressed and settled these issues, which the court irrefutably correctly found it did not. As Judge Hawthorne correctly pointed out through his question, there is no explicit finding along the lines advocated for by the appellant here. And in fact, the very paragraph cited to by the appellant in his argument as containing the language on which he relies makes clear that the monthly statements and the payments to be made are to reflect the amount due under the perpetual interest provisions of the GPPA. The arbitrators, far from saying the GPPA no longer applies and look only to the language of this award, refers back to the GPPA. It is the controlling contract. And that was the issue that was primarily before the panel, because in the history of the negotiations between these parties, there were in fact a series of 3 agreements reached in a very short time period in the early 80s when this oil and gas field was in the early stages of being developed. There was what's referred to as the FRSA, the MA, and finally the GPPA. And after Nordic, the original interest holder of this perpetual interest, declared bankruptcy within 2 or 3 years of the GPPA being entered into, a dispute arose between the parties about, first of all, whether any of the agreements survived the bankruptcy, if any of them did, which continued and controlled, and then if the GPPA continued to be in effect and controlled. There were some very narrow and specific questions before the panel related to the operating costs and capital costs, such as whether this fractionator facility that was not yet constructed, it was in the process of being constructed and didn't yet come online, would be included in that calculation. And those are the issues that were heard, litigated, and decided.
Was one of the questions before the arbitrators whether payout went in and out?
It was not, Your Honor. And in fact, just as we look at the timeline, the historical timeline of the events, the arbitration occurred in 1988, and that's the date of the award. The first payout, the first time that DCP had recovered its capital costs for the construction of the then existing facilities and had to pay anything, didn't happen until 1990. So this was not even an issue on anyone's mind because the first payout hadn't even occurred. So it was absolutely not something that was before the panel. It was not something that was argued, and it was not something that was decided in this decision.
Can I ask you about the cross appeal?
Yes, I was going to move to that. Thank you.
Okay, well then you can go ahead.
Okay.
Okay.
So yes, I will move to our cross appeal now, of course, pending any other questions regarding the appeal. So DCP has cross appealed one issue coming out of the district court's declaratory judgment order. In the court's order, the court modified or ordered under its declaratory judgment a modification to DCP's volumetric method for allocating capital. The problem with that modification is that it cannot be squared with the factual findings that are necessarily implicit in the jury's verdict in favor of DCP on our counterclaim.
Okay, so let me just jump in with a question,
Yes.
clarifying factual question. At trial, was there an alternative way of calculating the costs that was presented by the other side that the jury said, no, we don't agree with that, we agree with the way that DCP is doing it?
Yes, Your Honor, there was. Both sides retained experts who have expertise in oil and gas accounting, who presented to the jury their opinions and calculations with respect to what the amount owed or that should have been paid under this perpetual interest during the relevant years should have been. And DCP's expert used the same volumetric method that DCP uses and has used during the course of this business dealing, and opined that that was a proper method, that it was consistent with the industry, with how in oil and gas accounting you account for similar types of interests, and opined as to the dollar amount that using that method, DCP was owed under its money hadn't received claim back from the plaintiffs because DCP had inadvertently overpaid those amounts to the plaintiffs and was entitled contractually under the GPPA to have kept those amounts before making any payment. The jury awarded to the penny that amount that DCP requested. Now, under the plaintiff's breach of contract.
Let me interrupt you there a
Yes.
minute. They may have awarded to the penny the amount that your expert opined about, but were they asked on the jury verdict form to decide which method of allocation was the proper method for allocating the perpetual interest amounts?
No, Your Honor. It was a general verdict form, so there were no special interrogatories or anything else, or no area in which the jury indicated on the verdict form which of the competing testimony or methodologies that had been presented to it was choosing. But that's why the fact that the jury agreed with DCP's methodology is an implicit finding that is necessary for that counterclaim verdict to have been reached. Because DCP presented no other grounds, no other theory, no other argument on which the jury could have awarded that amount. The premise of the counterclaim was that DCP had overpaid the capital costs. If the verdict on behalf of the plaintiffs meant that DCP had paid the wrong amount because it had now I'm confused on over versus undercharging. But if the plaintiff's verdict had been premised on the jury deciding that the methodology presented by the plaintiff's expert for calculating the amount of the perpetual interest was wrong, was wrong with respect to capital, they could not have at the same time awarded DCP the amount that it requested based on overcharging capital. They're just inherently and irreconcilably inconsistent. And to crystallize this, the capital cost issue was not the only grounds of breach argued by plaintiffs and presented to the jury.
Okay, but before we get there, hold on. Okay, the provision that DCP is objecting to, that the district court imposed, was something having to do with, well, you can't have these like far-flung production centers being counted as part of your
The
cost,
distant
correct?
facilities, correct.
Okay, did that come up in the plaintiff's theory of what the cost should be, how you should allocate costs? Did they say, well, wait a minute, jury, they're trying to allocate costs for these far-flung production sites? Was that part of their theory?
They did. They presented evidence that some of the sort of more recently built facilities in the DCP super system, as we call it, which is an interconnected processing and gathering system up in Mold County, where the gas can travel sort of anywhere in the system. The plaintiffs did argue to the jury that certain of the facilities that were in an area, the furthest sort of area from the AMI, that there was no way that the gas could reach those facilities. And so the plaintiffs did present a theory that to the extent that they were having to contribute to the capital construction costs of those
You have
facilities.
about 30 seconds left if you want to wrap up.
Thank you, Your Honor, that violated the GPPA. But if the jury agreed with that, then the jury could not have awarded DCP everything it requested on its counterclaim. And the plaintiffs presented 5 different breach bases, 3 of which were revenue related. And because of that, there is a way to read these verdicts consistently, which is the court was obligated to do, and to then issue its DJ consistently, which it was obligated to do. So we ask that the modification of the volumetric method be reversed. Thank you.
Thank you. Thank you, both counsel, Mr. Byrne, Ms. Pennington. Thank you very much for your arguments. Those arguments are going to be very helpful to the division in reaching a decision in this case. Counsel are excused. The court will stand in recess for just a few minutes so we can reconstitute the court, and we'll be back. The bailiff may so announce. Thank you. Thank you.
Just always resting on it. I can never get it to like hook in. Yeah, so it's fine. Okay. Straighten everybody's chair, straight.
Thank you. Please be seated. Welcome back to Division 4 of the Colorado Court of Appeals. I introduced myself earlier, but for those who are here now at the conference, or at the council's table, I'm Bob Hawthorne. I'll be presiding over the proceedings today. The panel is made up of me, and to my right is Judge Terry Fox, and to my left is Judge Elizabeth Harris, will be the division reaching a decision in this case. And the next case we have, I want to, just a few things. Are there any questions about our practice and procedure protocol here in these appellate arguments? An appellant, as you know, you can reserve some time if you wish to do so. The time is self-monitoring by the timing device on the podium. I'll remind you that we are live streaming oral arguments these days, so if there's anything sensitive or confidential, you may want to keep that in mind. If anyone has come in since the last admonition about cell phones, please make sure that your cell phones are turned off, or any other device that might go bump in the night and disturb the arguments here. So with that, we're ready to proceed on Marriage of Scaturo, 2017 CA17. Counsel, you may proceed.
Good afternoon, Judge Leonard Baronato, 13693, appearing on behalf of the appellant who was the respondent in the trial court level, Pasquale Scaturo. May it please the court. Judge, the court's aware that the parties in this case entered into a settlement agreement on November 30th of 2010. The settlement agreement provided that the petitioner would be awarded 1/2 interest of any hyperdynamic stock or any interest that the respondent had in the Hyperdynamics Corporation or the Hydrocarb Corporation, which the respondent currently has, and that's as of November 30th of 2010. On November 20th of 2015, a petition was filed requesting reallocation of the assets under Rule 16-2E10. That petition...
Can I interrupt you right there,
Sure.
Counsel? Because I have to ask this question. I know that neither party raised jurisdiction of the trial court in this case, but I don't know if either one of you are aware of the case Marriage of Runge.
Yes, Your Honor.
Okay. Can you address that quickly for me?
Judge-
And I know no one argued it, but there are 3 opinions in that case, one of which is the dissenting opinion, which opines that the trial court in this case, or in that case rather, did not have jurisdiction because of 16.210. And the facts seem very similar here. This was filed, 10 days before the 5-year
That's
period elapsed.
I think in this case, the court did retain jurisdiction because the separation agreement specifically provided that she would get 1/2 of any interest. So if the petitioner subsequently learned that there was an interest in these corporations, I think that the court had jurisdiction for those issues only, and that's one of our concerns here. So the parties, I think, intended for the court to maintain jurisdiction over the issue of Hyperdynamic stock and the Hydrocarb Corporation. With respect to the rest of it, I don't believe that the court has a jurisdiction on that. But you're absolutely correct, Judge. Nobody argued the jurisdiction. What the court did here was they filed this petition talking about stock ownerships in Hyperdynamics, ownership interest in Hydrocarb Corporation, and they raised 2 other issues, an interest in a property in Africa known as Sparwater Farms, and stating that he didn't provide financial information for all the businesses which he had. And so the court, in essence, when we got to trial, opened up the entire case. So we were dealing with not only the Hyperdynamic stock and the Hydrocarb, but we were also dealing with, as noted in our appeal, the Seismic Specialists, Inc., which isn't even addressed in the permanent orders. It was the respondent's position that Seismic Specialist was premarital property, and I'll get into this later, but that's not even referenced in the settlement agreement. So it's our position that they waived anything to that. But Judge, So that's the first issue. The court essentially opened up the entire property division, which I've never seen before. I mean, usually these cases are you didn't disclose a pension or you didn't disclose some asset, but I've never seen one where we just willy-nilly, we just opened up the entire case for a reallocation. So the first issue, Judge, is the hyperdynamic stock, which the court did retain jurisdiction on. And what happened there is the respondent in July of 2009 was appointed to the board of directors of a corporation known as Hyperdynamics, Inc. It's an oil and gas company. That happened in July of 2009. When he was appointed to the board, he received options to purchase stock at a set price, 50,000 shares of stock. Those shares were immediately exercisable, so he could have exercised them right away, which he never did. So then 2 months later, in September of 2009, he was granted another 44,000 options. 22,000 were exercisable in October of 2010, 22,000 which were exercisable in October of 2011. So what happens next is in October of 2009, before the dissolution started, the chairman of the board came to him, and this is all on the record, and said, I want you to resign. I've got somebody else to take your place. And he said, fine. He resigned, and he left. And so the divorce action got filed in November of 2009. His first financial disclosures were due in December of 2009. So in December of 2009, it was his position that the options lapsed upon termination of his employment. And that was indicated in Exhibit B, Respondent's Exhibit B at the trial court level, which was a filing of Hyperdynamics Corporation with the Securities and Exchange Commission, which specifically says options terminate on your last day of employment. What happened was the corporation's next regular board of directors meeting was in February of 2010. And so what happened is they said at that board of directors meeting is when they actually accepted his resignation. But he didn't know that. I mean, in October of 2009, they said, we want you gone. He left, and as he stated in the record, I never thought of these options again. And that's why the options weren't disclosed. So what happens is the court then makes a determination, looking back 5 years later, and the court makes a determination that these are property interest under balancing, and therefore they should have been disclosed. Well, the problem is that the first set of options, if you accept the court's premise, which I have to do because that's what the court found, but the first set of options, the 50,000 shares, there was a property interest, and if you say they had been disclosed, then the court could have entered an award of those. But the other two options, they come due in October of 2010 and October of 2011. Those are options which are based upon his continued employment on the board of directors. So even if you follow with the court's rationale, where the expert of the petitioner stated, no, the options were good for 90 days subsequent to termination. He would have had to employed in August of 2010 and August of 2011 to ever exercise those options. Those options never came into play. They were never a property right, and they were never something that could be divided by the court. So what happens is if you just take the first set of options, and it's listed as Group A in Exhibit number 48 of the trial court, those options were worth $12,000. At the time of the resignation, even granting that the resignation didn't take place until February of 2010, which we disagree with. But it's $12,000, so it's our position that that's really not a material omission when you look at the rest of the assets which the petitioner received in this case. She received approximately $500,000 in property and pensions and maintenance, et cetera. So it's really a very small number. So it's a position of the respondent that I didn't even know I had these options. I was under the impression that they expired in 2009 when I resigned, and that's why I didn't disclose them. So the next issue that came up with the court was this company is called Seismic Specialists, Inc. And Judge, this is really the Runge case here. The court, Seismic Specialists, Inc. was a business that the respondent owned premarital. They put together a database for oil and gas drilling in Michigan and Indiana. And what happened was, over the years, they would sell that sell that geological information for money, and that's the way the company made its business. Well, in 2009, at the time of the divorce, the company in 2006 made approximately $500,000. 2007, it made $78,000. In 2008, it made $900. And in 2009, there was no sales whatsoever. So when the respondent filed his initial disclosures, he put in there the value of the business, zero.
Counsel, does our record disclose what the increase in value of SSI was during the marriage?
There was no increase in value, Your Honor. It was a position of the respondent that the value of the company in 2009 was simply the value of the data, because the data was all that they were selling at that point. Because there had been no sales essentially in 2 years prior to the dissolution, what happened is, in the supplement to the record, we submitted an affidavit of the owner of the company saying, we paid $10 million for the data in 1986. In 1998, when the parties got married, we believed that the data was worth about $700,000. And in 2009, 2010, when the parties got divorced, the data was worth $400,000. So it's our position that there was no increase in value of the marital estate based upon the value of the data. What happened is the court allowed the parties to supplement the record, and the petitioner submitted a new expert's report, which basically did it as a stream of income. Because what happened is, in 2011, there was fracking came in, and there was a boom in oil prices where oil went to $100 a barrel. So all of a sudden, this data had some inherent worth. And what happened is, the respondent's partner, he went out into the oil fields and he called it a fire sale. I just sold it to everybody. I practically gave it away. So what happened is, you had some income numbers in 2010, 11, 12, which is the numbers that the expert took to get this stream of income. The problem with that is, in 2009, or 2010, when they got divorced, you didn't have those numbers. So all you've got is declining revenues over a 5-year period. And so with no, as a testimony at the trial was, nobody had any idea that oil was going to do that, and that's why he thought the value of the data was zero at that point.
But can I just ask a couple quick clarifying questions? Sure. You're not challenging, and you didn't challenge, did you? Or maybe you did in the trial court, but you're not challenging on appeal the actual methodology used by the expert, are you?
We never got the opportunity to. What happened is the court said, I'm going to give the respondent 21 days to supplement the record as to the marital value of the company. I'm going to give the petitioner 14 days to respond, and then I'm going to issue a ruling. So we never had the opportunity to challenge it.
But you had the opportunity to put in your own valuation. Didn't the court say, I don't have any information here about the value of the company. Could somebody please put in some information to both parties?
Right.
And then husband called somebody to say, instead of zero, the actual value of the company was about $400,000. And
Right.
they had their person say, well, we think it's closer to $1 million.
Right.
Okay, so
And
you had an opportunity to put in.
Oh, and we did put in the value, but the problem is that the petitioner put in a valuation based upon, one, did not respond to what we did. So it was, you put in your valuation, the petitioner gets to respond. They didn't respond, they just came up with a whole new valuation using a whole different theory. The problem that the court stated in its order was that if I can just have a moment here, the court stated in its order that it was the data that was never valued. And so what we did was we took the position that the only value of the company in 2010 was the value of the data, because there were no sales being made. So we based the company's value on the value of the data. And that's where we came up with the $400,000 number. What the petitioner did was they took an expert's report that we never had a chance to argue about or look at the numbers or anything, and they said, we've got a stream of income based upon sales in 2011, 12, and 13. Well, those numbers weren't available in 2010 when the divorce was done. So if you had done an expert analysis in 2010, what would have happened is you would have seen a 5 years of declining sales down to zero. So there's no way you could assume that those numbers would increase in the years gone by. So you'd have to base your expert's report on that declining sales over that period of time. And so that's the problem with the way the court allowed an expert report to come in at the very end of this case. I don't know if that answered your question or not. Okay. So, and then the final issue, obviously, is the issue of attorney's fees. Where we were in this case is you had four basic issues: the hyperdynamic stock and the hydrocarb, and there was a whole. The basis of the case was based upon this hydrocarb analysis, and hydrocarb was an oil concession in Africa. And the issue was, did the respondent have an ownership interest in that? And the court made a determination at the end of the case. The respondent had no ownership interest in the hydrocarb company or the Ovambo concession, which was the majority of what this case was about. And yet the court went ahead and ordered all the attorney's fees in this case, all the expert costs, and basically said, this matter is so convoluted that I can't really tell what attorney's fees are related to what issue, so I'm just going to award everything. I believe, and the court also said that there was a matter of obfuscation on behalf of the respondent, which also caused her to make that award. Now, she never explained what that obfuscation was, but that was the basis of the attorney's fees. So it's our position, Your Honors, that there's no basis to, regarding the stock, there's no basis to award money on what's known as Block B in the expert's report. With respect to the SSI, that was fully disclosed. And so you can't come back in under the Runge decision, you can't come back in and revalue something that's had previously been disclosed at the time of the trial. And the third issue is the attorney's fees, is that the court never held a hearing on the reasonableness of the attorney's fees. The court never held a hearing under 1410-119 as to the relative incomes of the parties, but simply just said, I believe that he obfuscated this matter, and I'm going to award them all the attorney's fees. Even though out of 5 sections of this trial, the respondent was successful in 3 of the 5. So basically what the court...
Counsel, your time has expired.
Oh.
You're in the hole.
Oh, I didn't know what that meant. I kept looking down, it kept going back up.
It
I
goes
apologize.
back up, yeah.
Thank you, Judge.
Thank you. And counsel, I'm going to ask you the same question before you begin.
Of course, yeah.
Or this will be a part of, you can start the clock.
Yeah, may it please the court, I'm Sam Storm in 11894 on behalf of Kim Scaturo, who also appears today.
Thank you. I'd like to hear your
very
take on the
very briefly,
case.
Your Honor. I would agree with Judge Richmond in that case. Judge Richmond seemed to have hit it on the head. Because of the vagaries of the trial court's docket, by way of example, I could see situations where a motion under 16.2E10 is filed timely, well within the 5 years, but it doesn't get heard, perhaps because of discovery disputes, because of people's illnesses, because the court's docket is backed up. You get bumped because there's a higher priority case that needs to be heard that day. It doesn't get heard in the 5 years. It would render the rule virtually meaningless. He says that in the Runge case, the court's jurisdiction to reallocate was properly invoked when the wife moved for it within the 5 years, and having been properly invoked, the court's jurisdiction was not then lost when the court didn't rule on the motion until after the 5-year period had expired. It seems to be the only way that the rule could be interpreted. Absent that, you'd have people filing them on an abundance of caution because there's an inkling of maybe there's something that wasn't disclosed. I find out about something, and so it's analogous as well to, let's say, a motor vehicle accident or any other statute of limitation issue. It's going to implicate the idea that if you file this paper before the statute of limitations has run, but you don't get to trial until the statute is expired, And you would lose your right to suit. There's a tolling that occurs when that happens, and I would argue that the same kind of tolling, by way of analogy, occurs in a 16.2E10 petition. That until such time as it's heard, that court's jurisdiction is not lost.
Thank you.
Hopefully that answers your question. I'll also point out something that counsel pointed out about reallocating the marital estate. Shelp was very clear about that. And once there's been a finding that the marital estate was not fully disclosed and the court has to reopen it, it is an entire reallocation. Shelp says so right in the ruling. And so that's what the trial court was cloaked with, and that's what the trial court was attempting to do. I won't spend any time talking about the fiduciary duties and the 16.2E10 obligations of disclosing information without being asked. I think that's pretty straightforward. It's set forth in the brief. But what I will do is point out that the trial court is best suited for determining the credibility of the witnesses, determining what occurred, weighing the evidence, observing the witnesses. In this case, the trial court found repeatedly that Mr. Scaturo didn't produce information because he felt, and I'll quote, "I didn't have to." Quote, "I was getting a divorce. Why would I?" There are entire file cabinets in Namibia that Mr. Lauder testified to that were there, that Mr. Scaturo told him what and what not to produce. Mr. Lauder was an officer for the company and was charged with the obligation of maintaining those records. The disclosures that were made, finally, as a result of the petition, showed that there were a number of assets that weren't disclosed at the time of the divorce. Very briefly, the hyperdynamics stock and stock options, Exhibit 36 spelled out, and these are all SEC documents that are filed.
I'm sorry, can you just address the issue, though, about whether or not those were ever going to be able to be exercised?
They were fully exercisable according to the documents that were filed with the Securities and Exchange Commission. Exhibit 36 says that they're fully exercisable.
The set of B stock, the Block B stock?
These are 50,000 shares that were a part of a 10K that was filed with the Securities and Exchange Commission June 30th, and it says, and I quote, "They're currently exercisable options."
Right, and they concede that the 50,000 are, but that's all they concede. So what about the rest of them? The other Block A stock and the Block B stock?
Those were all provided to Mr. Scaturo according to the SEC documents that we reference in our brief, and he had an option to exercise them.
But how, if they don't vest until October of 2010 or 2011?
There's nothing in the record that indicated that. There's nothing in the record that indicated that he had to be there and do that to be able to exercise them. In other words, be part of that company. They
So
were
he
earned
could-
by him as compensation.
So he can resign, wait a year, and then exercise the option, you're saying?
That's what I understand from what the SEC documents indicated.
But wasn't there testimony to the contrary?
There was from Mr. Scaturo.
Right, and
which
it's
was-
incumbent upon the trial court to make its credibility
It's
determination.
exactly right.
Okay,
I
and
think
it
she
did
was-
so.
Yeah, Judge Offler was very clear what she thought about Mr. Scaturo's veracity. I will address very briefly the SSI issue, and you know, I think it's really harmless error. Their own expert came and said it was worth $400,000 at the time of the divorce, and that's pretty much what the trial court did. And so the idea that she asked us, as you point out, Your Honor, that we could both supplement the record, and they chose to do it in the manner they did, we chose to do it in the manner we did, I think is telling. There was no evidence, and there isn't anything in the record. Let me back up. As you know, there's a presumption that all of this is marital property until one party, by clear and convincing evidence, proves that it's separate for one reason or another. There was no evidence submitted by the husband in this case that any of this was separate property. There was no evidence of valuation at the time of the marriage to show what the appreciation was, for instance. There was no evidence to show that he acquired it after the marriage. And so all of this is marital, and all of it should be presumed to be marital. I'd like to move on briefly, because I see I'm about halfway through my time, to our cross appeal, because this gets a little bit more complex. Mr. Scaturo, as you know, is a well-known geologist. Mr. Scaturo was associated with a man named Kent Watts in the hyperdynamics deal. He was associated with Kent Watts in a whole plethora of companies, all of which ultimately morphed into hydrocarb. Doros, by way of example, is one of the iterations of this entity. Doros obtained the Awambo oil and gas concession, 27,000 square kilometers in Namibia. Doros was registered the day after the divorce. Mr. Lauder and Mr. Scaturo both said that the Awambo concession was locked up prior to the divorce. The question was, which entity were they going to take this concession in? It ultimately ended up in hydrocarb. Mr. Scaturo testified on cross-examination that his reward for that, for securing the Awambo concession, which he had started his work to attain it back in 2009 and throughout 2010 while they're still married, his reward for doing that was these millions of shares, 25 million shares in the company, which ultimately provided him a 39% interest in the concession. It's the identical case to the Johnson case that we cited to you in our brief. It's no different than the commercial or the residential real estate broker who puts the parties together. There's a contract, the closing is set, it happens after the divorce, and in that case, a panel of this court found that that is marital property. I'd submit to you it's the same thing, because otherwise you reward a party for putting it off until the day after the divorce.
And I think as a theoretical matter, that all makes sense, but as you have said twice now, the court gets to decide what
Sure.
the fact findings are. And the court says, in this case, that husband did not acquire the interest until after the marriage.
I agree, except she did do that. She took us right up to the edge and then stopped. There's a page and a half of the findings about how he had this interest, he was negotiating and everything else, but she said there was nothing that she could see in the record that indicated that he had actually acquired that during the marriage. And I think that's true. I think that's true.
Well, then how are
But-
we supposed to say it's clearly
Well-
erroneous?
Well, because you can look at it and you can say that as a matter of public policy in this state, we're not going to reward someone who clearly violates 16.2E10 and Rule 16.2 as the trial court found. And you can say that the overwhelming evidence here, because it is overwhelming, I believe, is that he had an interest. He testified at trial he had this interest. He had it locked up in November of 2010, he said.
So then, just to clarify, your position is that the court did clearly err, that the record does not
That's right.
support her determination
That's exactly
that the
right.
husband acquired this after the marriage?
That's exactly right.
Okay, so it's not a public policy, you don't have to
Well-
rely on public policy, you can just say there was evidence in the record and it went your way, not the other way.
That's fair. That's fair.
Okay,
That's fair. He testified that he obtained the concession during the marriage in exchange for the shares of stock that he ultimately received. Remember, he held himself out as the president and the COO of the same company. It was represented publicly that he was the co-founder of the company. He testified that there were never any shares issued between him and Mr. Watts during the marriage. The shares were only issued after the divorce. I think it's very, very clear when you look at this, when he testifies that while he's here in Denver getting his divorce, he's putting the final touches on the deal. He then flies back to Namibia the very next day, December 1st, to close it. Again, I appreciate your comments, Your Honor. I really do. I get it. I just don't know how can we stop this kind of behavior from occurring in cases like this if we're going to say, it's okay, the more you conceal it, what we'd be saying is the more you conceal it, the better your chance of getting away with it is. And that's exactly opposite of what all of these cases, the Hunt case, the Shelp case, even Runge and the rule say that we should be careful of. There's one other issue, and that is the nondisclosure of his businesses in Namibia. The trial court didn't address it. He has two businesses, basically, Spar Water and solitaire. He never produced any of the financial information for either one of those entities, not at the original time of the divorce, not at the time of the hearing in summer of 2016.
Counsel, but wasn't it incumbent upon both parties to address that issue in connection with the separation agreement?
No.
Why
it's-
not?
Well, because Hunt says, even though she knows about it, it's his job, because he's running it, to produce the 16.2 and the Form 35.1 disclosures, the financial statements, the tax returns, the bank documents. That's exactly what happened in Hunt. What you're asking is, the husband there told the wife about it, she knew about it, but because he didn't give her the financial documents voluntarily without her asking for them, that panel found that it was a violation of the rule and it needed to be reopened and reexamined. So here what we have is, we have a company that he values at zero, two companies that he values at zero at the time of the divorce, tells her about it, doesn't give her any of the disclosures, but we now find out in 2015, this is a supplement, we filed a motion to supplement the record because we found a mortgage application where he says it's worth $2 million. That happened in 2015, admittedly, so it's a few years later, but it's the kind of disclosure that you're supposed to make at the time of the divorce and wasn't made here. It's indicia of the fact that this was a substantial marital asset that wasn't disclosed. It's indicia of the fact that he knew that it would be worth something at the time of the divorce. It's a huge operation there. They have a huge hotel and a gasoline station and a bakery and a restaurant, and people come and they do tours to the game preserves, and they do all of these things, and you didn't disclose any of that.
Can I ask a quick clarifying question? It seemed like the issue with the Namibia money was that there had been money taken out of the marital account and put into something in Namibia.
That is
That's
another.
only part of it? Is
Yeah,
that what
that's
you're
part of it. What we established, Exhibit 77 is in evidence. It's $680,450 that disappeared during the marriage, that has never been addressed by the trial court. We asked the trial court to address that. It was uncontroverted at trial that those monies were wired to Namibia. He never disclosed where they are. He never provided bank statements or anything of that nature. He never put it on any financial affidavit. And
Okay,
so
but this is a separate issue now, you're saying.
is.
But in addition to that, there's also these businesses
That's
in
right.
Namibia, and there was nothing disclosed about those other than the fact of their existence.
that's correct.
And that was put in front of the district court, and the district court does not say anything about that.
She's silent. Her order is silent regarding it. And so we're asking that we be allowed to have that analyzed, that divided, valued. I see I'm just about out of time. I will say on the issue of attorney's fees, this was a very, very difficult case to find information. It's across an ocean, for crying out loud, the other side of the equator. It's a long ways away. Information technology to get stuff from Namibia, it wasn't coming from Mr. Skatura, I can tell you that. And so we spent an ungodly amount of time. Finally, let me just tell you, we did have a hearing, notwithstanding counsel's statements. It was May 11th, 2017. There's a minute order on that following the hearing, and you'll see that in the record.
And before Judge Hawthorne tells you you're out of time, can I ask you a quick question?
Yes, ma'am.
So all of that, the sort of contentious nature of it and the obfuscation and all that might go to reasonableness of fees, but the court says it was going to award fees because of I can't remember, the provision that says the person who has more money has to pay. But did the court ever determine anything about who has more money and who can pay?
Well, she did. She found that there was a substantial portion of the marital estate, the parts that she did look at, that Mr. Scaturo had.
But for
And-
purposes of the fee award,
Right.
was there a determination that under that provision of the statute, that because he was in a position to pay, he had to pay?
What happened at that hearing, Your Honor, we were prepared with testimony. They asked for the hearing, and when we were getting ready for the hearing, they withdrew their request for a hearing. And so we never, it's interesting, the minute order says that we had a hearing on that day. It says that the order will enter based upon the hearing at that time. But what really happened was Mr. Scaturo's counsel withdrew their objections and withdrew their request to have an actual hearing on that day. So I can't tell you exactly what was in her mind because she never told us, but I will tell you that she made clear findings that he purposely failed to disclose. He wasn't credible. He was manipulating witnesses in terms of disclosure of information, and it was, I think, in accordance with what she ultimately ruled.
Thank you.
Thank you.
Thank you, counsel. Mr. Storman, we're going to put 2 minutes on Mr. Storman, right? Am I getting it right? I'm sorry, I'm looking at the wrong one on the ad issue sheet here.
Mr. Bernardo.
Plus, I don't have my glasses on. So. Mr. Bernardo?
I took some extra time too, Judge. I don't know anyone else
Well,
check that.
council had about 2 minutes more time than you did, so we're going to put 2 minutes on for Mr. Bernardo to respond solely to that question that Judge Harris asked.
Regarding
The attorney's fees
Oh.
and whether or not there were sufficient findings made under 119.
Judge, I don't believe a hearing was ever held where we put that in. I certainly did. I don't know whether Mr. Stormer is thinking of a different case or not, but I didn't withdraw any motions because we'd just gotten hit with $170,000 in attorney's fees on that, and I believe there was another 60 or 80. I don't even remember what was awarded in that May hearing, Judge. So we contested the attorney's fees all the way through, saying we essentially won the three big issues of this case. The Ovambo concession at one point, their expert was saying that Mr. Scaturo had $13 million worth of stock. And so we contested all their attorneys' fees, saying you gave $27,000 to an expert witness on the Ovambo concession who testified that Mr. Scaturo had this locked up, as counsel says, and she awarded that to him, and we said, well, you found against them. How can you award $27,000 in an expert witness fees for that? Likewise, Judge, on the issue regarding SSI, they did an expert's report that never had a valuation, and we said, how do you charge us for these costs associated with this, where we actually won? And that's where the court said it's so interconnected that I can't really tell. I believe that attorney's fees is they're awarded by exclusion, not inclusion. I mean, I don't think that you don't reward somebody for going on a wild goose chase. I get it. They had to go to Namibia and this, that, and the other thing. But the fact of the matter was that they ran up hundreds of thousands of dollars on what the court essentially found to be a wild goose chase, and then she turns around and awards it anyway. And that's the part that's somewhat disturbing to us, is that the amount of these attorneys' fees based upon which were essentially a wild goose chase. Thank you, judges.
Thank you. I'm sorry for the name mix-up there. I should learn to put these on. Yes. Thank you for your arguments. Those arguments are going to be helpful to the division in reaching a decision in this case. And with that, the matter will stand submitted, and an written opinion will issue in due course. That concludes our docket for today, and so the court will stand in recess, and the bailiff may so announce. Thank you.